Good evening to everybody, to the aspirants of the JCJ 2022, and which screening test will be going to be held on 13th August 2022. So today is a mixed multiple choice questions, and the host, it's me, Dr. Professor Mohammed Saheb Hussain today. Okay, now first question goes in this manner. Are you ready? Say yes. Are you ready?
Yes, sir.
Good. I appreciate. Yes. First question. Dash of the Contempt of Court Act, which reads, I quote, a person shall not be guilty of contempt of court for publishing any fair comment on the merits of any case which has been heard and finally decided. A person shall not be guilty of contempt of court for publishing any fair comment on the merits of any case which has been heard and finally decided. I am quote. As per the section A option section 5, B option section 5 capital A, C option section 6, and D option section 6 capital A. Shoot. I say shoot.
Which is out of syllabus.
But it is a civil procedure practice rule, it may come. And criminal practice of rule, it may come. Yes? Anyone?
Section 5, sir.
It is a section 5. It deals about the Contempt of Court Act. Yes. Second question. The Contempt of Court Act passed in which year? Option A 1970, option B 1971, option C 1972, option D 1973. No negative marks. Shoot. What happened? Or just say pass on.
Some, sir.
The answer is 1971. The Contempt of Court Act is 1971. And the contempt is deal about which cases? Civil cases, criminal cases, both civil and criminal cases, are only administration cases.
Both civil and criminal cases.
I told you it is relevant to it because it comes under the civil cases, it comes under the criminal cases. In the both the cases, contempt is there. Okay, fourth question. The right answer is C. For third question, is it clear? Say yes. Is it clear?
Yes, sir.
Say yes.
Yes, sir.
Good. Fourth question. In both the cases, that is civil contempt or criminal contempt, contempt proceeding must be initiated within dash from the date on which contempt is alleged to have been committed. Option A, 3 months. Option B, 45 days. Option C, 1 year. Option D, all of the above.
Option A.
Wrong.
Option B,
Option C, 1 year.
45 days.
Option B, wrong.
Option C, 1 year.
Then only the left one is option C, 1 year from the date on which the contempt is alleged to have been committed. That is the right answer for the fourth question is C, 1 year. The fifth question. Which section of the Contempt of Court 1971 deals with the contempt of court, both civil and criminal dash cases? A. Section 2 Class A. B. Section 2 Class B. Option C. Section 2 Class C. Option D, all of the above.
Option B.
Wrong.
Option A, Section 2A.
Wrong.
B to option B.
WRONG, wrong.
Option C to
All
class
of
C.
them above.
Option D is the right answer. Feedback you can see. The Indian legislature does not provide with a concrete definition of the contempt. However, Section 2, Class A of the Contempt of Code 1971 says contempt of court means a civil contempt or the criminal contempt. Section 2B and 2C of the Contempt of the Code 1971 defines civil and criminal contempt. Then the answer is?
All of the above.
All of the above is the right answer. Sixth question. Dash deal with the period of limitation for initiating the contempt proceedings as per the Contempt of Code Act 1971. Section 18, option B, Section 19, option C, Section 20, option D, Section 21. The limitation period of 1 year in contempt cases, both the civil and criminal act, option A, B, C, D, shoot. No, though it is wrong, doesn't matter.
Option
Option
C,
B,
Section
section
Option D.
Option D, wrong.
Option B. Option B.
Option B, wrong.
Option C, Section 20.
Section 20 is the right answer for the sixth question. The limitation period of 1 year, both the civil and criminal cases for the limitation period as per the Contempt of the Code Act 1971 is Section 20. TWENTY, 20. Okay.
Sir, all
Seventh
these
question.
questions are
Can anyone but yes? Lavanya, do you want to speak anything?
nothing, sir. No, sir. No, sir. Nothing, sir.
Okay, read the seventh question. Anyone can unmute and read. I said read.
Dash is explicitly mentioned as an offense under Section 354C of Indian Penal Code 1860. Option A, lesbianism. Option B, incest. Option C, voyeurism. Option D, sodomy.
Option C, voyeurism.
C.
Right answer is option C, voyeurism. And I believe that everybody knows what is lesbianism and incest and sodomy. Okay, the supplementary question, you can go through it. Eighth question. Anyone can unmute and read? The person who read should give the chance to other persons. I said read. Bhavana, can you unmute and read?
Any man who follows a woman, contacts her or attempts to contact her for personal interaction time and again even after the woman has indicated clearly that she is not interested in making an acquittance amounts to stalking as per A. Section 354A, B. Section 354B, C. Section 354D, Section D, Section 354E.
Option C, 354D.
When you are reading, you have to read in this fashion. Option A, Section 354 capital A. Option B, Section 354 capital B. Option C, Section 354 capital D. Option D, Section 354 capital E. So the right answer for the eighth question is C, Section 354 capital D is the right answer. Shall I proceed?
Yes, sir.
Okay, very good. Anyone can unmute and read? Please give the chance to other people. Nagarao. Nagarao. Oh, Nagarao, can you unmute and read the ninth question?
Smriti Irani is
Ninth question. NINE 9. Multiple choice question. HRD minister, read. Please, somebody come to his rescue.
HRD Minister dash spots camera in trial room of dash in Goa. Option A, Smriti Irani and Fab India Candolim. Option B, Smriti Irani and Fab India Candolim. Option C, Smriti Irani Feminist Candolim. Option D, Smriti Irani and Fab India's Candolim.
The voyeurism case law, it is from the Goa. At the time, HRM minister was there and she pointed out, highlighted it. And
Option A, Smriti Irani and Fab India Candolim.
option
A.
wrong. WRONG, wrong. Next
Option
option.
B. Option B.
Read.
Option D.
Sir, option A and D. Same. What is the difference
Spelling
between
is
A and
different.
D?
Okay. See, A and B not the same. I say Fab India's Candolim, in the B say
Okay.
Webinars Candolim. Different. The right answer is
Option D.
option D. Smriti.
Option D.
SMRITI, Smriti Irani, 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 ampersand, that is the equivalent is and Fab India's Candolim. That is the right answer. Is it clear? Say yes.
Yes, sir.
Yes, anyone can unmute and read the 10th question. Please read those who are not read. I would like to hear your voice.
out of from Information or Technology Act, which was observation in the case.
Read option A. Shreya Singhal versus Union of India. B. Ibrahim Shine versus Union of India. C. Joseph Shine versus Union of India. D. Shayara Bano versus Union of India.
Ibrahim.
Option A is the correct answer. Priya Gautam.
Option A. SHREYA. Shreya Singhal. SINGHAL. Singhal versus Union of India is the right answer for the 10th question, where the section 66 capital A is struck down. Okay, next 11th question. Anyone can unmute and read? Anyone can unmute and read. Sri Vidya also present there. I don't know. Can you read, Vidya?
Section 497 is struck down as unconstitutional, being violate of Article 14, 15 and 21 of Constitution was observed in the case of option A, K.S. Puttaswamy retired and another versus Union of India and another. Option B, Shreya Singhal versus Union of India. Option C, Shaira Banu versus Union of India. Option D, K.S. Puttaswamy retired versus versus Union and another. Option A and D are same, sir.
Yeah.
Option A or D.
Yes. It is case Puttaswamy retired and another versus Union of India is the right answer for the question, where the 497 is struck down. Supplementary question. What is meant by 497?
Adultery.
Yes. I appreciate. Yeah, 12th question. I will read. Dash of the CRPC, which contains the procedure for the prosecution under chapter dash of the IPC, shall be unconstitutional only to the extent that is applicable to the offense of adultery under section 497 of IPC. Option A, section 198, subsection 1 and rule 20. Option B, section 198, subsection 2, 21 rule. C option, section 198, subsection 2 and 20, and that is section 198, subsection 1 and 21 rule.
Option B,
Option
sir.
B. D.
Who
Section
said option
198.
D
D is the
is
correct answer.
D is wrong?
Option B. Section
Option
198.
C,
Subsection.
section 198, subsection 2, and the rule 20, Roman 10:10. Okay, 13 question. Anyone can unmute and read loudly.
Supreme Court held that though adultery may not be an offense, it will continue to be a ground for seeking divorce. Was observed in the case of that A. Siddhartha Bhatt versus State and
Yes.
others. Option B. Farhan versus State and another. Option C. Mr. Mohammed Shamsher versus State of Karnataka. Option D. Joseph Shine versus Union of India.
It's an easy question.
Option D. Joseph Shine versus Union of India.
The answer is yes. Option D, Joseph Shine versus Union of India. It was decided in that manner. The 14th question. In Joseph Shine case law, which major sections are discussed? Option A, section 497 of IPC. Option B, section 198 of the Code of Criminal Procedure. Option C, only A. Option D, both A and B.
Option D. Both A and B.
The answer is both A and B is the right answer. First I thought of changing the 197 to 196, but later on they said, no, let me see that how it can be made. So section 197 of the Indian Penal Code and section 198 of the Code of Criminal Procedure and article 15 subarticle class 3 also be discussed over there. Yes, 15th question. National Legal Service Authority versus Union of India. Case. Who are the other two petitioners in the transgender case law? Number A, Pooja Mehta Nasib Kaur G Women Welfare Society within parenthesis NGO and Lakshmi Narayan Tripathi. B, Pooja Mata Nasib Kaur G Women Welfare Society within parenthesis NGO and Lakshmi Narayan Tripathi. Lakshmi Narayan Tripathi. C, Pooja Mata Nasib Kaur Ji Women Welfare Society within parenthesis NGO and Lakshmi Narayan Tiwari. D, Pooja Mata Nasib Kaur Ji Women Welfare Society NGO and Lakshmi Narayan Tripathi. There are total 3 petitioners are there in addition to the National Legal Service Authority. So I give the option A, B, C, D. And which is the appropriate answer?
Option D.
Option D. Pooja, P-O-O-J-Y-A, Pooja Mata, M-A-T-A Mata, Nasib, N-A-S-I-B, Nasib Kaur Ji, Women Welfare Society, within parenthesis NGO versus, and she is the well-known activist in Lakshmi Narayana Tripathi. She is a well-known activist in Hijra, H-I-J-R-A, Hijra community. Or we can say Hijda. Are you following me?
Yes, sir.
Good, good. What do you say Hijra in English language? If you know it, you tell me. If you don't know it, you say
Transgender.
Transgender.
English language, there is a specific word for the Hijda.
Transgender.
That is the terminology is there for the legal terminology. In the English language, there is a specific word is there. I say English language. I did not say legal terminology.
Transgender, sir.
E-U-N-U-C-H. Eunuch. E-U-N-U-C-H. Is it clear?
Yes.
Yes.
Yes, sir.
Can you read the feedback?
The National Legal Service Authority of India, within parenthesis NALSA, was the primary petitioner. It had been constituted with the primary objective of providing free legal aid services to the disadvantaged sections of Indian society. The other petitioner in the matter were the Puja Mata Nasib Kaur Ji Women Welfare Society, a registered society and NGO, and Lakshmi Narayan Tripathi, a renowned Hijra activist.
Yes. 16th question. Anyone can unmute and read? Loudly. Nagarao, can you try?
No, sir.
Why?
Voice not continuing myself.
Mobile data is not good. I could hear your voice very clearly.
Voice clearly not comes, sir. Network is come.
If you try it, tinaga tinaga vepaku tiyaganundu. Try.
Who is the IPS officers handling the neighbor in
Nirbhaya case.
case?
Number A. Option A. Chaya Sharma. Option B. Sharma Chaya. Option C. SARMA Sharma Chaya. And D. Chaya SARMA Sharma. Which is the right answer? Shoot.
Sir, A. Chaya Sharma.
The right answer is A. CHHAYA Chaya SHARMA Chaya Sharma. A option is the right answer. The IPS officer Chaya Sharma was the Deputy Commissioner of Police within parenthesis South in Delhi in 2012 when she handled the investigation in the brutal Nirbhaya gang rape case. 17th question. What was the name of Nirbhaya? Spelling.
Jyoti Sharma.
Spelling.
JYOTI.
There is no JOYTHI.
TI, only TI. A.
JYOTI.
JYOTISINGH. Among the four, which is the right option?
Jyoti Singh.
Option B is the right answer for 17th question. Feedback. Nirbhaya was born as a Jyoti Singh in the Balia district of Uttar Pradesh in the year 1899. What is the age of Nirbhaya at the time of the
18
offense?
375.
I say age, AGE, age.
18.
Say percent.
14 or 15 years.
23 years age. What is her career? What is her career? Study. Anyone? If you are not mistaken, physiotherapy. And the person to whom he is having the affairs is already a married fellow. Okay, 18th question. Who was last hanged in India? Of course, I have already given the answer. Akshay Thakur. Okay, tell me rest of the other three. Tell me rest of the other three. Akshay Thakur. Nirbhaya's case victims. Total 4 are. One is acquitted. Akshay Thakur, Mukesh Singh, Pawan Gupta, and
Vinay Sharma.
See, you are seeing the screen. I don't know why you are not giving the answer. And who are hanged to on 20th March 2020, supplementary question. Hanged on 20th March 2020 were the last person to be executed in India. What is the mode of execution in India? I repeat. What is the mode of execution of death sentence in India?
Hanging.
Hanged to death or hanged till death.
Till death.
Okay, 19th question. Dash executed on 3rd January 1955 at Tihar Jail is presumed to be the first woman executed in the independent India. Who is that independent India woman executed in 1955 in the independent India? Of course, if I give the options, you are ready to give the answer. A. Ratanbai versus Ratanbai Vaishali. B. Ratanbai Kaur. C. Ratanbai Jaint. D. Ratanbai Jain.
Option D, Ratanbai Jain.
Are you sure? To me, the answer is different. Okay, let me check it. Because why I should have to keep it in hide and seek?
Option B.
Because I also a little doubt is there. That's why I'm getting the doubt. It is a Kaur or it's a Jain. It is a doubt. Ratanbai Jain is the right answer. You are right. It is the Ratanbai Jain is the right answer for that question. 28th question. Can anyone unmute? No, it is a big question. I will read it. Which statement is acceptable statement and true or correct statement? A. Hanging is an act by strangling or breaking the neck by a suspended ring. B. Hanging is execution by strangling or breaking the throat by a suspended nose. And C. Hanging is execution by suffocating or breaking the throat by a suspended ring. And D. Option. Hanging is an execution by strangling or breaking the neck by a suspended nose. Which one is the correct statement? Okay, I will give the hint. Nose is the right word, not ring. Okay, now you tell me. And nose is given on only the two options. Option B and
Option D.
okay, now you choose which is the correct answer. Hanging means
Option D.
among the B and D, which is the correct answer?
In both NOOSC, suspended nose.
But something is changed.
Neck is added in fourth.
Throat is right word, neck is right word.
Neck. Option
Neck
D
is right word. Throat means where the passage will goes, especially the food, that is called throat. But the neck means the entire part of it.
Entire neck.
So the nose will go entire part of it. Is it clear? Say yes.
Yes, sir. Yes.
So right answer is
Option D.
option D is the right answer. Okay. Okay, now you tell me. Read this one, 21 question.
Who was Damini? Option A. It is a Hindi movie. Option B. It is a historical movie. Option C. It is a real story of a rape girl. Option D. Correct A and B. A and C. Option A is the right answer. Hindi movie.
It is not only a Hindi movie.
Option D. A and C.
It is not only a Hindi movie. It also a real story of a rape girl. And her name is Damini. They put it over there. Can you tell me who is the actor in the Damini?
Meenakshi Saheb.
I say actor.
Rishi Kapoor and Sunny Deol.
Yeah. And the main role is by Sunny Deol. A 23-year-old gang raped victim battling for the life in a Delhi hospital has been named Damini by thousands of people who are supporting her and the streets and via social networking sites. The name draws the inspiration from a Hindi film on a woman's fight for justice for a rape victim. 22nd question. Who defended the 4 convicts in Nirbhaya case? Yes. Who defended the 4 convicts in the Nirbhaya case? Sir, show me the 4 options. We will give the answer. Okay, 4 option is here. A. Ajay Pratap Singh. B. Arjun Pratap Singh. C. Ajay Pandey Singh. D. Amar Pratap Singh. Sir, we don't know, sir.
Option C. Ajay Pandey Singh.
We know only AP Singh.
Option C.
Wrong. I know that you know only AP Singh. But I don't know.
A, option
I
A.
want to give the full form of it. Yes.
Option A, Ajay Pratap Singh.
The right answer is A. Ajay Pratap Singh is the right answer. 23rd question. Match the following cases from Part A and the principle laid down in the Part B. Part A, Bachchan Singh versus State of Punjab. Second, ADM Jabalpur versus Shivakant Shukla case. Third, Justice case Puttaswamy versus Union of India. And fourth, A.K. Gopalan versus State of Madras. The B options. Preventive Detention Act 1950. B. Right to privacy case. C. Known as a habeas corpus case. D. It was a death penalty case. Option A. 1A, 2C, 3D, 4B. B. 1C, 2B, 3A, 4D. C. 1B, 2D, 3C, 4A. And D. 1D, 2C, 3B, 4A.
Option B, sir.
Option D.
Option B.
1D, 2C, 3B, 4A.
It is option D is the right answer. 1D, 2C, 3B, 4A. And see the feedback. Bachchan Singh it's about it was the death penalty case. ADM Jabalpur versus Shivakant Shukla case is known as a habeas corpus case. Supplementary question. What is meant by habeas corpus?
To produce the body.
The body must be present. Okay, Justice case Puttaswamy versus Union of India, right to privacy case. A.K. Gopalan versus State of Madras, Preventive Detention Act 1950. So that was the relevant cases over there. Now match the following cases from Part A and the principle laid down in the Part B. 1. Brij Bhushan Sharma versus Delhi. And 2. State of Madras versus Champakam Dorai Rajan. And 3. Swapnil Tirupati versus Supreme Court of India. And 4. Shafin Jahan versus Ashokan KM. And the Part B said live streaming or video recording of court. And B. Love Jihad case. And C. It is the freedom of speech and speech recording cases of the public interest. And the D. Caste-based reservation in admission to the educational institutions. Answer here is 1D, 2B, 3A, 4C. B. 1D, 2D, 3A, 4B. And option C. 1B, 2C, 3A, 4D. Option D. 1C, 2D, 3B, 4A. Okay, I will drag it to the next page so that you could see total. Yes. Shoot. Even though it is wrong.
Option D.
Option C.
Neither option D is correct, nor option
C.
C is correct. No, I think there is something. I think D is correct. Let us see. Which one is correct? Brij Bhushan Sharma versus Delhi. It's the freedom of speech and speech recording. And State of Madras versus Champakam Dorai Rajan is caste-based reservations in admission to the educational institution. And Swapnil Tripathi versus Supreme Court of India, live streaming or video recording of the court proceeding in case of public interest. And Shafin Johan versus Johan KM is a love jihad case. Now you tell me. Yes? Love jihad case is. So the right answer is D.
D.
Okay, next 25th question. Match the following cases part A and the principle laid down in the part B. Anuradha Bhasin versus Union of India. Second, Mukesh Kumar and another versus State of Uttarakhand and others. Option 3, Amish Devgan versus Union of India. Option 4, Union of India versus K.A. Najib. In the part B, A, regarding what constitutes a hate speech, and B, bail in UAPA cases where under trial accused has been subject to the prolonged imprisonment. C, access to internet as a fundamental right. D, reservation is not a fundamental right. So option here given in 1B, 2A, 3C, 4D, B, 1D, 2B, 3A, 4C, C, 1B, 2C, 3D, 4A, and D, 1C, 2D, 3A, 4B.
Option D is the correct answer. 1C, 2D, 3A.
Option B is the correct answer. 1D, 2B, 3A, 4C. Anuradha Bhasin versus Union of India, it deals about the access to internet as a fundamental right. And Mukesh Kumar and another versus State of Uttarakhand and others, reservation is not a fundamental right. Amish Devgan versus Union of India, it says about regarding what constitutes a hate speech. And the last one is Union of India versus K.A. Najib, bail in UAPA cases where under trial accused has been subject to the prolonged imprisonment. Can you tell me what is UAPA? Even myself also I did not know. Yes, anyone?
Unlawful acts and prevention.
UAPA cases. Yeah, something like that.
Unlawful activities and prevention of activities.
Yeah. UAPA is, yeah, you are right, is unlawful activities within parenthesis Prevention Act is an Indian law aimed at prevention of unlawful activities association in India. Its main objective was to make powers available for the dealing with the activities directed against the integrity and sovereignty of the India. So that was the right answer. What you said is, I appreciate. Then 26th question. The Supreme Court of India, the right to housing and the interconnections of right decided in the case of course, is the only one famous case. I don't know whether you know it or not. I repeat, it's a global case. The Supreme Court of India, the right to housing and the interconnectedness of right decided in the case of, means it is about the easement also. There is a landmark case law is there globally and people use this case law. Can you tell me that case law name? If I show the option, definitely you will tell the case law. There is no doubt at all. Yes? It is about the easement. When the covenant is given, you are not supposed to construct the free land any house. That means you are not supposed to construct. There is a landmark case law is there. Okay, now I'll show you. Olga Tellis versus Bombay Municipal Corporation. It's a landmark case law. Olga Tellis. If I show the options, I am sure that definitely that you will tell me because it is a case law about the house interconnection where the covenant and easement is concerned. Is it clear?
Yes, sir.
Good. 27th question. Description of the accused as per the form number 73 under the criminal rules of practice. A. Serial number, sequence, name, father's name, next race, residence, occupation. Which is the correct form? B. Serial number, name, father's name, occupation, race, residence. The next, serial number, name, father's name, occupation, residence, race. D. Serial number, name, father's name, race, occupation, and residence. Which is the correct sequence? In the form number 73 of the criminal rules of practice.
Option D.
Option D is the correct answer. It's the serial number first, name comes, father names comes, race comes, occupation comes, residence comes, later on age and other details. 28th question. Summonses of the following classes of medical officer in the district should be issued in the manner specified below. One is odd man out among four. One is not related regarding the summons are concerned to the medical officer. A. Government medical officer in a government medical institution. B. Government medical officer in Jilla Parishad and Municipal Taluk headquarters medical institutions. C. Government medical sent for the services in the Jilla Parishad and Municipal medical institutions. And D. Jilla Parishad and Municipal medical officers. One is not connected with it, but other three are very much connected with the summons. What is right? There is no wrong in the government medical officer in government medical institution. Either you say government medical institutions or you can say government medical colleges. Because colleges are also institution and the university also said to be institution. Right. B. Government medical officers in the Jilla Parishad, yes. And municipal taluk headquarters, yes, they are also considered, and medical institutions. Even medical officer means a person even practicing Unani or Ayurvedic or homeopathic or allopathic, they are said to be the medical officers. Am I right?
Yes, sir.
Good. And C, government medical officer sent for services in Jilla Parishad. It is not sent. It is lent. Government medical officer lent for services in Jilla Parishad and municipal medical institutions. So I removed the sent, I removed the L, I put the S. It is not sent for services, it is lent for services. Is it clear?
Yes, sir.
Sir, do they ask such type of questions? I gave a model so that you could not say the type of the question will not be asked. Is it clear?
Yes, sir. Okay.
Yes, 29th question. As per the section 23, criminal rules of practice, cases where an accused has absconded after appearance, what are the rules are applied? A. Rule 18, 19, 20 and 21 shall apply as far as may be to cases where an accused person has appeared and but has subsequently absconded. B. Rule 19, 20, 21, 22 shall apply as far he may be to cases where an accused person has appeared but has subsequently absconded. C. Rule 20, 21, 22, 23 shall apply as far as may be to cases where an accused person has appeared but has subsequently absconded. D. Rule 17, 18 and 20 shall apply as may be to cases where an accused person has appeared but subsequently absconded. I have shown the feedback. I don't know whether you've seen it.
Already option is there.
Yes?
I have seen already. Option B.
It is B. Rule 19, 20 and 22 Rule 19, 20, and 21 and 22 should apply as there may be to cases where an accused person has appeared but has subsequently absconded. That is the answer for the question 29th. Is it clear?
Yes, sir.
30th question. Yes, can anyone unmute and read?
Section 24, receipts of FIR as criminal rules of practice, which is false among four. Option A, magistrate and judges receiving FIR shall initial each page and put the date, stamp, day and time of receipt. Option B, the name or number of the messenger shall also be noted. Option C, if the FIR is received by the post, the envelope shall also be initialed and preserved. Option D, the same rule applies to inquest report and other documents received from the police or other prosecuting agencies.
Option D.
Wrong. It's very tough.
Option C,
Option B, sir.
WRONG, wrong.
option C,
WRONG.
Option A.
I say A is wrong, is the right answer for that 30th. Can you tell me why? Can you tell me why? WHA, why?
Magistrates and judges. I think there should be only
No, both are there. Magistrates means lower rank, will say magistrates. A little higher rank will say judges. Of course, sometimes no.
Period of date, stamp and everything.
And one thing is I added there, actually it is not there. Pages and put the date, stamp. There is no day. Stamp and time of receipt, no day. Day is not mentioned there. Date, stamp and time of receipt. I added day. I told you, no, it is a tough. There is no day, but I added. Is it clear?
yes, sir.
super tough.
So only stamp, date and time, no day. Because the date itself, we know that what is the date. Is it clear?
Yes, sir.
Yes, 31st question. Whenever a magistrate remands an accused person to the custody of the police under dash of the Criminal Procedure Code, a copy of the order remand with the reason recorded thereof shall be forwarded within 24 hours to the sessions judge. As per the section 165, B option section 166, C option section 167, D option section 168.
66, sir.
WRONG.
Option C, 167.
Yes. It is option C. 167 is of the Criminal Procedure Code is the right answer. And then the 32nd question. Which section says about the person who could not heard more than 7 years are presumed to be died as per the section of Indian Evidence Act? Option A, section 105. Option B, section 106. Option C, section 107. Option D, section 108.
Option D is the correct answer. Section 1.
Section 108.
It is 108. Option D is the correct answer. Okay, I told you not spelling. Can you tell me what is the not spelling? I already told you what is the not spelling. Can anybody repeat the not spelling? Sir, we know it, sir. N-O-T not.
Next station. K-N-O-T.
N-O-U-T. N-O-U-T.
N-A-U-G-H-T.
Tell us, sir, one more time.
N-O-U-G-H-T. Either you can write both N-A-U-G-H-T or N-O-U-G-H-T. That is the spelling. Okay, can anyone unmute and read the 33 question? Please read. Why you are taking time? Only 6 are left out today. No matter. Even one person also get benefited out of my lecture. I feel that my mission is fulfilled. I say read. Srividya, read.
The evidence law is regarded as dash, which directs and assists the court in reaching and deciding
Decision.
decision when dealing with a particular case. Option A, forum law. Option B, lex loci. Option C, lex causes. Option D, all of the above. Option B, sir.
WRONG, wrong.
Option A.
It's a lex fori, but means law of the forum. The right answer is
Option A. Option A.
option A. Feedback I am giving. I told you, this is a private international topic. I am a bit good in the private international law. Law of the forum means where the case is filed, or forum where the case is filed. In other words, we may also say law of forum or lex loci too, but generally lex loci, the place where, but lex fori, the place where the substantial law of the other country could be used. Okay, lex causae means it's the law of the causes, and the lex causae and which type of the offense it is committed is called lex causae. Is it a tort offense? Is it a contract offense? Is it a succession offense? That's the lex causae. And in the law chosen by the forum court from the relevant legal system when it judges an international or interjurisdictional cases. So the legal doctrine of lex fori means choice of the forum, and lex loci, choice of the law, means other country law, are intrinsically important that the debate for resolving the international dispute for trade, commerce and tort, including the contract, because contract is nothing but trade and commerce. There is a customary fight over the jurisdiction issue also. International litigations are there when the customary law could be used over there or statutory law could be used over there. So that would be a different aspect of it. Okay. So law of the forum means lex fori. Okay, 94th question, 34th question. I read it. In dash, apex court held that, I quote, when a statement is made by a person as to cause of his death, or as to any circumstances of transaction which resulted in his death, in case in which the cause of his death comes in question is admissible in evidence, such statement in law are compendiously called dying declaration. I am quote. It is observed in the which case law? A. Ulkaram versus State of Rajasthan. B. Pramila et Nina and others versus State. C. Vikas and other versus State of Maharashtra. And D. Lakhan versus State of Madhya Pradesh. It is about the dying declaration. Shoot.
Option A.
Option A. Tulkaram versus State of Rajasthan.
Yes, the answer is option A. Ulkaram versus State of Rajasthan. Supplementary question. What is the classical case law in the dying declaration? I repeat. What is the classical case law in the dying declaration?
Pakala Narayan Swamy versus King Emperor.
That is a Indian case law. I say classical case law, landmark case law, the first case law, the turning point case law. Say pass on.
Pass on.
Pass on, sir.
To me, either is a Kuhn versus Abdullah or R versus Abdullah.
Yes,
Check it.
yes, it is.
Yes, I think that the Kuhn versus Abdullah, I think I'm right. or R versus Abdullah? And what is the classical case law in the minors contract is void?
Mohri Bibi versus Dharmadas Ghosh.
It is the Mohari Bibi versus Dharmadas Ghosh is the classical case law where we can say it. Even though there are number of cases are there where it is made, but still the classical case law is counted a lot. Okay, 35 question. What is the purpose of Hindu Marriage Act 1955? Which one is false statement among the four options? A. The main purpose of the act was to amend and codify the law relating to marriage among Hindus and others. B. Besides amending and codifying the Sanskrit law. C. It also included separation and divorce, which also exists in the Shastric laws. D. This enactment brought uniformity of the law for all sections of Hindus. This is already told.
Option C.
Repeat.
Option C. It is also included separation and divorce, which also exist in Shastric law.
Besides amending and codifying the Shastric law, there is no Sanskrit law. There is no Sanskrit law. It is the Shastric law, S-A-S-T-R-I-K, space capital L-A-W. Is it clear?
Yes, sir.
Okay.
This already I told. I don't know why you forgotten this thing. And in law of contract, privity of contract is fallacy. And which is the landmark case law?
Dunlop Pneumatic Tire Company versus Selfridge Company.
Good. In tort, of course, there is no question of tort is there because that the same thing would be when it turn into the not from the contract, but separately independent of contract, then we can say tort. And I told already that one case law which will distinguish between a contract and tort. What is those two case laws? In both the cases, minor hairs mare, M-A-R-E mare means M-A-R-E mare means, say pass on if you don't know.
Pass on, sir.
Pass on.
Vidya,
Pass on, sir. I'm
how could you say pass on? You are my student. A female horse is called mare.
yes, yes, yes.
And what about the male horse? There is a Hollywood actor, Rambo 1, Rambo 2, Rambo 3. And his name, the word is there. Sylvester Stallion. So male horse is called stallion. Spelling S-T-A-L-L-I-O-N. So female horse is called mare and male horse is called,
Stallion.
okay, pony. What is meant by pony? P-O-N-E-Y. I don't say the ponytail. The style of wrapping the hairs in the pony style manner. That is the horse style manner. Pony is a child of a horse. Is it a masculine gender or a feminine gender?
Feminine.
Wrong. It is a neutral gender
Masculine.
like horse. And the female pony is called a small female horse, a baby horse. A female
Masculine.
baby horse called pony is called filly, Filly, filly. And the male baby horse or pony is called colt, Colt, colt. So now in the contract, a minor made the contract with the mayor and subsequently he has given to his friend and friend used for his overriding, then horse become limp. That is a one contract case law. In the second also, a child hired a mare, but when hiring he put the condition that you should not use this mare for the lurking, Lurking, jumping over the poles or hurdles. But he made it, consequently the horse died. So in contract, a child is not liable. In tort, a child is liable. And in my earlier classes, I already discussed these two case laws. What is those two case laws? For contract, I told Jennings versus Randall, Jennings, Jennings versus Randall, Rundall. And where in the contract a child is not
Liable.
why you are taking so much time in the tort? Bernard versus Huggies. Bernard, I think Burnerd, Bernard versus Huggies, Huggis. And there says a tort arising, not arising out of the contract, a tort arising independent of the contract, not out of the contract. So a separate, it's not from the contract because the negligence part is over there, hence there is no contract, it's turned into the negligence part appeared over there, not used for lurking, but he used it, means the negligence on the part of it, hence the child is liable. Is it clear?
Yes, sir.
Then I already told the flick knife case law. Flick knife, Flick, flick knife, Knife. What is the name of the case law? I already discussed this case law in our earlier classes. And I already told there what the principle is held over that case law. Merely keeping a tag and put it on the windows, it is only invitation to sale. It is not a sale. What is the name of the case law? You already studied the contract and it is a very landmark case law, that is Fisher versus Bell. Spelling Fisher. Fisher, Fisher versus Bell, Bell. What is the principle involved in the case law? As per the Weapons Act is concerned, it is merely a invitation to sale. It is not a sale. Keeping a tag with the price in the windows, the window shopping. Window shopping is a real shopping? Give me the answer.
No, not shopping.
Window shopping is not the real shopping. So keeping the tag on the window is not amount to the sale. It is only
Sale.
invitation to offer or
Or
invitation to sell.
invitation only.
And what is that case law? Where it says intention to create the legal relationship, and hence he deposited £100 in the Imperial Bank. It is not a puff. P-U-F-F puff. I don't mean that is the egg puff or chicken puff. It's a false statement. Puff means not smoke round puff also. What is the name of the case law? Participants, are you there? Participants, are you hearing me?
Yes, sir.
Speak loudly. What is the name of the case law? Srividya.
Maybe Balfour versus Balfour.
Carlyle versus Carbolic Smoke Ball Company case law. Is it clear? Say yes.
Okay.
Yes, sir.
Three-piece suit case law already discussed. Number 1, trouser. Number 2, coat. Number 3, waistcoat.
Waistcoat.
What is the name of the case law? Is it a necessity to a minor? The necessity is supplied to the minor. The amount can be reimbursed. What is the name of the case law? If you don't know, you say pass on.
Moses versus Smith-Sterling.
Repeat.
I think Moses versus Smith-Sterling.
WRONG.
Ash versus Enum.
Nash versus Iman. NASH. Let me check. Iman versus Nash or Nash versus Iman? Which is the right
Versus-
answer?
It's
me,
Nash only. Sir.
Nash versus
Nash
Iman.
versus Imam.
Versus Enum.
Nash versus Iman is the right. Yes, Nash versus Inman, not Iman. Inman. I-N-M-A-N. Inman. Not Iman. Nash versus Inman. That is the case law where the King's Bench has given the judgment in the Indian case law. One of it, a tailor supplied the 13 waistcoats and other things to that kind to a undergraduate student, and when he is studying in the Cambridge, brought him against from the recovery of the price of those goods. Issues whether the goods so supplied fall into the category of the necessary. Number 2, if the answer is no, whether the contract was enforceable at law. 3, on whom does the onus to prove or the dispute the necessity of goods so supplying for. So this is the case law where it is clearly held that supplying the 13 waistcoat is not necessary, and hence the tailor is not going to get the amount because it is no more a contract. It is not a necessary. So that is the case law, Nash versus Inman case law. There it is held. So now Cisco WebEx is very much kind enough to you. Of course, I do have a lot of things to deal because I collected only some of them and I did not totally made the things, but still, and regarding the old question paper discussion means people are having the less interest or they want to enjoy the Sunday holiday mood. Perhaps that is the reason. The strength is
Three.
Very less.
pardon? The strength is
Less.
Less strength, only 3 or 4.
Professor Hussain students will not say less. Professor Hussain students will say, sir, we don't know. Here I will say, the student strength is, this is Professor Hussain student style. What is that? What is that? What is that? I put on the screen. Can you read? Participants,
If we
Student
read also, you will say
yes.
something.
Make
no doubt you are also right. No doubt you are also right. But the polished language is, what is the polished language? I shown you just now.
Mere.
Meager. MEAGRE.
yeah.
MEAGRE.
GRE.
That is something provided or available lacking in quantity or quality. They were forced to supplement their meager earnings. So that is the thing. With this, I would like to stop my today's class. And the next class, what is the next class?
Regarding NI Act and DVC, sir.
On the date?
Tomorrow, 8th.
And the NI Act means Negotiable Instrument Act and
Domestic.
Domestic Violence Act.
Domestic violence.
What is the main cases in the NI Act? Which section can be used? Which section?
138.
138.
What is that 138 says?
Dishonor of check for insufficient funds.
What is the another name for the dishonor of checks? What is the another name for the dishonoring of the checks?
Bouncing.
Set
Check
bounce.
bounce
Check bounce.
cases.
Check bounce.
Yes, of course, the law still not implemented over there. The new law is passed, but still the rules and regulations are not there. That's why still we are not using it. Okay, with this, that I would like to close up my today's class. Thank you very much for your patient listening. And I told you that Jai Hind.